Good morning. Good morning. Good morning. Good morning. I hope you can hear me this morning. When I got the settings on my mic correct yesterday, I put a piece of tape over it so I won't accidentally bump this stupid wheel. How do I sound? Than stuffy. How do I sound? Can you hear me? Because I went back and I listened to yesterday a little bit, and I am so sorry. You guys were right. You couldn't hear me. I mean, not that um I believed you, but I did not realize how awful the sound was. It was bad. So good morning. My name is Debbie. Welcome to my channel. Um uh Shadow decided that I don't know if you can see. She wanted to play this morning. Well, you can't see the one on my arm. You see the one on my hand. She wanted to play. And because I have had cats for so many years, I am like, I've built up a little bit of an immunity. So, hey, Robbie. So when I'm just holding her and loving on her, like it doesn't affect me anymore. But when you go below the skin, it does. So she was very playful this morning, and so now I'm having an allergic reaction. So I'm fine. I'm just having an allergic reaction to Shadow. So let's see what Judy has for us today. Will the jury connect all the pieces? I certainly hope so. That is one thing that frustrates me about our justice system, which is a very good system, but and they do in closing arguments try to connect the dots, but a lot of what our justice system is just presenting evidence and then the jurors have to connect the dots. And I connected the dots with the car fire. Um she asked the car dealer about his make and model of car and the engine fires and it being recalled, but his car did not have that extra package, whatever it was. I didn't understand. I'm not a car person, but some kind of extra package that he would have had to add into the car that would have recalled it. So then I guess he knew about that. So he decided, I'm going to set the car on fire and then pretend that the engine caught on fire. But that wasn't like explicitly connected the dots for the jury. That's something they got to figure out on their own. That is the one thing that I don't like about our justice system. I think that the attorney should be able to get up there and say, he trashed his he put his car on fire and then was going to use the recall to say my engine caught on fire. But they're not allowed to do that. The jury has to make, they, what is it? Infer and imply. I get those mixed up. The lawyer has to imply it and then the jury has to infer that's what they were implying. And it aggravates me because there are times when I don't put two and two together until way later and I'm like, "Oh, that's what she meant. That's why they brought that up." So that aggravates me a lot about our system, but it is what it is. So, Portal Hunt Club. The club was established back in the late 1800s. The members of Portal have hunted the property for about 110 years. They are believed to be the oldest still functioning hunting club in Georgia. However, there were 2 years during World War II when the club was closed as the Army used the land for training. I thought there was one remark about this hut club that I thought was really, really interesting is that it was founded, the people that founded it were from another county. And the reason why they founded it in another county is because their county had no deer. And I was like, what? Do deer, like, do they know not to go to that county? Like, why are there no deer in that county? That was just cray cray to me. Like, is there a sign up that says, deer, don't go to this county, they'll shoot you? Like, I don't understand. Good morning, Judy, Jill, Robbie. Hey, guys. I apologize for the watery eyes and the stuffy nose and the weird voice. It's Shadow's fault. So blame Shadow. But she's not a playful cat. So when she plays, I play back. She just doesn't know how to play nice because of Travis. Travis has taught her to play mean. So they have not started yet. So after I got off the computer, after we ended the live, I saw a thumbnail for Vinnie Politan Investigates, and it was about Brian Koberger. Did he pattern himself after the Gainesville Ripper? And some of you know, anybody that's new, I'm sure doesn't. If you explore my channel, again, I'm so sorry, guys. But if you explore my channel, you will see I have done a video on Danny Rolling as well as a live stream of his penalty phase trial because he pled guilty. Danny Rolling is the Gainesville Ripper. In 1990, in Gainesville, Florida, he killed 5 college students. He would wait in the woods behind, he picked his target. He would wait in the woods behind their apartment and study them until he decided the right time of night after they were all asleep to go in there. And he did horrible. Is it not loud enough? Again? I don't know what I'm going to do about this mic. I'm just going to talk louder. I hate this mic. I don't know why my mic doesn't work right. Is that better, Robbie? Because now I've forgotten which. I put tape over it because I got it right yesterday. And now I don't remember which way to move the wheel. Is that louder? I don't remember which way to go with this stupid wheel. Is that louder? I don't remember which way. And I put tape because I thought I had it in a good spot. I don't know. Hey, Terry. I need a new mic, I guess. There's no markings on this. You know, things that have volume usually have numbers so you can tell if you're going louder or not. This has no numbers. It has colors on a wheel. Anyway. So, Danny Rolling, in 1990, he killed 5 college students. He would wait out in the woods behind their apartments. Now, Gainesville has grown greatly since then, but I lived in an apartment that backed onto the woods. In fact, the way they were set up, there was apartments on this side and apartments on the back side by the woods, and I had to park in the front and walk around to the back. Um, I think I moved right around that time. I moved back home, and I can't remember if I moved before or during. I don't re- it I mean 1990, that was forever ago, so I can't remember. I also was in college, but I can't remember if I went that semester or not. But I did work in Gainesville. It's all kind of fuzzy, but the terror was still there. I mean, serial killer in the town where I lived, went to school, and worked. And I resembled at the time his victims, his target. I had the big, in fact, I showed Jill. Let me find it. I showed Jill yesterday. Well, how much did we talk after I showed her the pictures? Jeez. Well, where did they go? There they are. Okay. That is one of his victims. That is Krista Hoyt. I ended up. Why did it just get dark? That was weird. Okay. That is Krista Hoyt. I ended up working with her stepmother years later, which blows my mind. Her stepmother's a nurse. And now when I watch documentaries about this, her mom, her stepmom that I know is in the documentaries, which is crazy. And she's in the courtroom on my live stream, which is bizarre. Okay, so that's Krista Hoyt. This is me back then. Krista? Me. I was scared to death. Scared to death. And one day, I was at work and they wanted me to work a double. And no cell phones back then. I forgot to call my mom and let her know I was working over. And when I got home, she about killed me because she had been terrified the whole entire time because she had no idea where I was. And she thought that Danny Rolling had got me. So, but here's the thing, y'all. I watched this thing on Court TV last night. I watched a little over half of it because the more I watched it, the more upset I got. And I started to leave a comment and I was like, no, because it's Vinny and I love Vinny and I love Court TV. Okay, so Rod Smith, who was the state's attorney of our district, the state's attorney actually prosecuted this. Like, he didn't have any of the people in his office. He did it. The state's attorney did it. And it was for the penalty phase because he pled guilty. He is dead now. We killed him. I kept through the whole thing. I kept going, yeah, he's dead. He's dead. And if you guys want to go back and watch the live stream that I did of the penalty phase, Flash Fan swears that I dropped the F-bomb during that live stream. I don't remember. I said, Flash, I'm not calling you a liar, because I probably did. I just don't remember it. But, okay, so Rod Smith, the one that prosecuted him, good morning, Ken. So Rod Smith is on this interview with Vinnie Politan, and someone who went to UF at the time. Now, I'm not being racist. Please don't take this as racism. And this is one of the reasons why I didn't leave a comment on the video, because it'll come across as that. They picked a male African American to talk about the fear on the campus. Now, I'm sorry, bless his heart. He was probably scared too. I get that. But that was not who Danny Rolling was targeting. He was targeting me. He was targeting brunette, petite, white females. Why didn't Vinny interview one of us? That's what I don't understand. Why didn't he interview one of us? I don't get that. I don't understand that at all. Don't you think it would have made more sense to interview the target population? What do you guys think? Am I off base? Am I wrong to think that? I don't know. So, anyway, Brian Kohberger studied Danny Rolling. Like, studied him. Everything he could get his hands on. But he studied other people too. It wasn't just Danny Rolling. But he was a criminal justice major too, right? So was he studying, and he was going for his doctorate degree in criminal justice. So was he studying for school, for his degree, or was he studying because he wanted to be like him? Anyways, it was a good show. Like I said, I just couldn't watch the whole thing. Because sometimes I can handle stuff about the guy and other times I can't. And at first, I was good. And then it dawned on me that Vinny was interviewing the wrong person. I mean, I get it. Yeah, he was scared. And Danny Rolling did kill one male. But that was because he didn't expect him to be there. Because the girl that he was stalking had her roommate was a male, and I guess he didn't expect him to be home. And so he had to, in order to get to the girl. So I guess that, yeah, he was probably scared. But he wasn't the target of Danny Rolling. Thank you, Ken, because I was just about to say that right before you came in, and I was like, uh-oh. It's not, I'm not saying it. I am the last person. I'm colorblind. I don't care. You can be purple. Purple, green, black, blue. I don't care. But I just felt like that was the wrong demographic, because that is not, like I said, he killed one male, and that was not, that was out of necessity for him, because he couldn't get to the girl, because, and Manny fought back. Like, he fought hard to save his friend, because he knew if he didn't fight the guy off, that his friend was going to get killed. And he fought hard, but he lost, unfortunately. And there is a giant memorial wall in Gainesville to this day, 30 something years later. And that wall has been graffitied and painted over so many times, except for that one section. And it's illegal to tag the wall, but people do it anyways. In fact, there have been times when families of the victims have wanted to touch up the wall or add some little special something. They'll go to the mayor to get like a special permission to touch up that section of the wall. Yeah, I was like, why, what, why are you? I mean, there's also a possibility they couldn't find anybody. Um, find a female brunette that was on campus back then that wanted to talk about it, but I don't know. Um, but um, the reason why I did a video on him was because back when I was doing like the Criminal Minds thing and then the true crime, was because there is a um an episode of Criminal Minds that I think in part was based on Danny Rolling, because it's on a college campus and he's going after brunettes. But of course, that could also be Bundy too. Um, and then I had live streamed Ashley Benefield, and that was the first time I'd ever live streamed, and I had so much fun live streaming that one that I wanted to live stream another trial. But I didn't want to do it full time yet, so I wasn't looking for a live trial. And I thought, well, let me see, because I had heard that he pled guilty. See, this is how I was so removed from it, because after they caught him, I was like, I don't ever want to hear his name again. I don't ever have anything to do with it again. And I kept seeing that there was a trial, and I was like, he pled guilty. How is there a trial? Because I didn't realize that when you plead guilty, there's still a penalty phase trial. So I didn't understand. I was like, why is there a trial if you pled guilty? And then I realized what it was, and I was like, oh, okay, well, I want to see this now. Not even realizing that I could have actually gone to the trial. But like I said, I had just been like, back then I probably have not wanted to go to the trial because I was just done. I was like, they caught him, just throw him in there and lock him up and throw away the key. But in 2006, they executed him. So, and he had, the way they caught him was they got a tip from Shreveport, Louisiana. He had killed a family in Shreveport, Louisiana. It was a little boy. This is even more disgusting to me, because why? I think he knew the woman that lived there. So there was a little boy. He was in the living room watching cartoons. His grandfather was outside in the backyard grilling, like they were fixing to eat dinner. He was outside grilling hamburgers or something. And the aunt, which was the daughter of the grandfather that was outside grilling, I guess the grandson was there visiting, because the woman that lived there was his aunt, not his mom. But I guess he had been stalking that woman, and he went in their house and killed the little boy and the grandfather, and then did whatever horrible thing to the lady, and then killed her. Um, and so I don't know if I don't know details of, but I guess maybe they matched his DNA. I don't know exactly what the tip was, but anyways, that's how they connected. They connected those two cases, and that is how they eventually caught him. But and they caught him. He was in Ocala, which is in Marion County, which is like the next county over from Gainesville, the next county south. Um, he had robbed a bank. No, he robbed a bank in Gainesville. He robbed something else in Ocala, I don't remember, or shoplifted or something. And so they went to Ocala and picked him up for the Gainesville murders. Just he's just a horrible person. Horrible, horrible person. And he made tapes while he was sitting out in the woods behind their houses or apartments. He made tapes of what he was doing and thinking, and he played the guitar and sang, and it, just such a disturbed mind. Just such a disturbed mind. Wait a minute. Are they not showing jury instructions? Because somebody. Oh, technical issues on court TV. Well, that's why. Are they showing him on Law and Crime? Because I'm like, people in chat are saying he's reading this now and he's reading that now, and then, but it's nothing on court TV. It says technical issues. Judy, you just gonna let me sit here and talk all day? It would help if I use the right keyboard. Two keyboards and two mouses. Two mice? Two mouses? I don't know. Two mice. Oh, there we go. Okay. I'm sorry, guys. I did not realize that court TV was having technical difficulties. I thought we were waiting for him to start. You know, I heard that in Shane Madej's voice, right?
It's on here that I have articulated throughout the course of the trial, including the exhibits I used to refresh recollection, search warrants, things of that nature. Counsel and I have reviewed it. There is nothing on this USB other than what was used during trial. Counsel, do you agree to that?
That's correct, Your Honor.
We've also gone through all of the physical evidence, Your Honor, meaning the exhibits and the documents. There are four exhibits that have been removed. They are 1.109, 1.111, 1.110, and 1.117 because they were demonstrative. I have talked to counsel about as those could be considered continuing witness. Counsel and his client have communicated. They have determined that it is in their best interest to submit those to the jury and that they do not wish to have them extracted. They wish them to go back.
State agrees?
I don't have an objection, Judge. They're welcome to go back to the jury. Okay. That would include the autopsy, all the reports from the DNA analysts. That would include the reports from the tool mark expert, as well as the other experts, in this case, toxicology and so on. And counsel, is that correct?
That is correct.
And that was after talking to your client as well?
That is correct.
All right, very well, then those exhibits will go out to the jury.
Thank you, Your Honor.
The only question we had somewhat, Judge, was physical evidence. There are things like bloodstain cards, things of that nature. Counsel and I have talked about it, the totes themselves. Those things were touched by the crime laboratory and obviously are still potentially not something that they should potentially get without maybe some interaction with the court. So we're going to ask that all of the documentary and physical, like photographs, things of that nature, can go back with them. I don't have an objection or need a note for that. But if they wanted to, for example, see the knives or to see the totes or something of that nature, that they would just need to send a note to the court and ask to see them. Is that correct, counsel?
Yeah, we're in agreement on that, Your Honor.
All right, thank you.
Thank you.
Thank you.
All right, anything else before we bring the jury in?
No, Your Honor.
Nothing from the state.
All right, let's bring our jury in. Please turn the phones off or have them on silent. I'm going to have the court reporter hand you the verdict form that we've put together in this case, just to have a look. Here's one for the state. Yes, sir. All right, everyone, please be seated. Good morning, ladies and gentlemen of the jury. Good morning. And I'm required one last time to ask if you were able to abide by the court's previous instructions regarding access to media. Did we have any problems? No. All right, then I will now read you the law that applies in this case. Ladies and gentlemen of the jury, you are considering the case of the state of Georgia versus Nicholas James Kassotis. And this is Bill of Indictment number 2024 R67 in the Superior Court of Liberty County, Georgia, February term of court 2024. And the grand jury has indicted the defendant with the following offenses: Count 1, malice murder; Count 2, felony murder; Count 3, aggravated assault; Count 4, concealing the death of another; Count 5, possession of a knife during the commission of a felony; Count 6, possession of tools for the commission of a crime; Count 7, possession of tools for the commission of a crime; Count 8, possession of tools for the commission of a crime; Count 9, possession of tools for the commission of a crime; Count 10, possession of tools for the commission of a crime; Count 11, removal of body parts from scene of death; and Count 12, tampering with evidence. Now, you will recall at the beginning of this trial, in fact, the entire indictment was read to you. Your oath requires that as you deliberate and go through each count, that you read the entire language that's inserted in each of those counts. So, ladies and gentlemen, the defendant has entered his plea of not guilty to this indictment, and the indictment and the plea forms the issue that you have to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I charge you that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to the case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law given in this charge to the facts as you find them to be. Your oath requires that you will decide this case based solely on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses, any exhibits, admitted during the course of the trial. Evidence does not include the indictment, the plea of not guilty, and the opening or closing statements made by the attorneys or questions asked by the attorneys. Evidence may be either direct or circumstantial, or it can be both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average person. The law permits expert witnesses to give their opinions based upon their experience and training. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all other witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of the same witness that was made before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's testimony at trial. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe and what testimony you may not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. I charge you that a statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you must also consider to what extent the defendant was informed of his rights, as discussed below. The burden of proof is upon the state to establish that the statement was voluntary. That is, it was freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. Number one, the defendant has the right to remain silent. Number two, if the defendant chooses not to remain silent, anything he says could be used as evidence against the defendant in court. Number three, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questioning. And number four, if the defendant did not have money for a lawyer, that a lawyer would have been provided for him to represent him before any questioning and to be present with him during questioning. The burden of proof is upon the state to establish that the constitutional warnings were mentioned and that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of the witness and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up those rights, then you would disregard the statement entirely and give it no consideration in reaching your verdict. Ladies and gentlemen, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparisons is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparisons in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but it simply means the intention to commit the act that is prohibited by law. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. I charge you that a jury is not authorized to find a person who was merely present at the scene of the crime at the time of its perpetration guilty of consenting in and concurring in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution in most criminal offenses. The accused is on trial for the offense of malice murder and felony murder, and under Georgia law, prosecution for these offenses may be commenced at any time. The exact date on which the murder took place is not a material element of the crime of malice murder or felony murder because there is no statute of limitation for those offenses. Prosecution for all other felony offenses included in this indictment must begin within 4 years after the offense has been committed. Prosecution for any misdemeanors included in this indictment must begin within 2 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within the required number of years after the offense was committed, it would be your duty to acquit the defendant. Now, ladies and gentlemen, the law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proven in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Liberty County, is a jurisdictional fact and must be proved by the state beyond a reasonable doubt as to each crime alleged in this indictment. Venue must be proven by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Ladies and gentlemen, I will now charge you on the offenses that are alleged in this bill of indictment. Count 1 alleges malice murder. For malice murder, the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Ladies and gentlemen, count 2, the defendant is charged with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. I will now charge you on the elements of aggravated assault. For aggravated assault, the state must prove the defendant assaulted another person with an offensive
Hi,
weapon.
Jill.
To prove assault, the state does not have the person was actually. However, the state must prove that the attempted to cause to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is an object that is likely to cause or actually does cause death or serious bodily injury if used against another person. The presence of an offensive weapon or the appearance of such may be established by circumstantial evidence. The state is not required to admit into evidence the offensive weapon used by the defendant in order for the defendant to be found guilty of the offenses of malice murder, felony murder, or aggravated assault. I will now charge you, ladies and gentlemen, on possession of a knife during the commission of a felony. For possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing a felony, which is one of the following: a crime involving another person, concealing death of another, which is a felony, which I will define for you shortly. And I will now define for you the elements of possession of tools for the commission of a crime. For possession of tools for the commission of a crime, the state must prove the defendant possessed a tool or device commonly used to commit the crimes alleged in the indictment, and intended to use the tool or other device to commit a crime. With regard to the charge of possession of a knife during the commission of a felony or possession of tools for the commission of a crime, the state must prove that the defendant possessed the knives or other devices at issue in this case. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the knife, tool, or device. Constructive possession means that all times of the alleged offense, the defendant may not have had direct physical control over those knives or devices, but that he did knowingly have both the ability and the intention to exercise control over those objects. Now, ladies and gentlemen, in count 4, the defendant is charged with concealing the death of another. I charge you that the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. In count 11 of the indictment, the defendant is charged with removal of body parts from the scene of death. And I charge you that it shall be unlawful for any person to remove from the scene of the death or dismemberment of any person or any human body part thereof. Now, with regard to count 12, where the defendant is charged with tampering with evidence, I charge you that a person commits the offense of tampering with evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person or to obstruct the prosecution or defense of any person, he knowingly destroys, alters, conceals, or disguises physical evidence or makes, devises, prepares, or plants false evidence. Now, ladies and gentlemen, after considering the testimony and evidence presented to you, together with the charge of the court, if you should find and believe beyond a reasonable doubt that the defendant in Liberty County, Georgia, did commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty of that offense, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty. However, if you do not believe the defendant is guilty of an offense alleged in the indictment, or you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the accused defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts of this case objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to consider in this case. One of your first duties in the jury room will be to select one of your members to serve as the foreperson. He or she will preside over the deliberations, and he or she will sign the verdict, to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's point of view. Each of you must decide this case for yourself, but you should do so only after a full discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors. You are not permitted to conduct any research. You are not allowed to consult any other materials. And I don't believe that you'll have your phone, so I don't think that's an issue. So whatever your verdict is, ladies and gentlemen, it must be unanimous. The verdict must be in writing and signed by your foreperson, dated and returned to be published in open court. Now, ladies and gentlemen, we have prepared a verdict form that you'll be able to use. You will also have the indictment that fully sets forth all 12 counts. So as you go through the body of the indictment, you can read count 1, you can read through the entire language that is set forth in the indictment, and then you'll see that the verdict form says, "We, the jury, in the above title action find the defendant, count 1, malice murder." And there's a block that you can check not guilty or guilty. And it's the same for all 12 counts. So after you have reached a unanimous verdict, and it has been signed and dated on the back page by your foreperson, you would then simply knock on the door, tell the juror, the bailiff, that you have reached a verdict, although you would not disclose what that verdict is. Then we would bring you back into open court where your verdict will be published according to law. Now, there are going to be a lot of exhibits that will go out with you. These large boxes, the large boxes of physical evidence, we're not going to send those out with you at this time. But if you feel that you need to observe or look at those objects, if you would just simply write a note to the bailiff, and we'll be happy to bring you back out so you can take a look at the object that you wish to see. So I'm going to allow you to go back to the jury room at this time, but you will not begin your discussions and deliberations until you receive the indictment, the verdict form, and all of the physical evidence that will be sent with you. So you are excused at this time. All right, everyone, please be seated. Let the record reflect the jury's now out. Ms. Bayo, on behalf of the state, are there any objections to the charge of court?
There are no objections to the charge or to the verdict form, Your Honor.
Mr. Weinstein.
The defense also has no objections to the charge or the verdict form.
All right, thank you. So we've already reviewed all the exhibits. They're in proper order. I assume we can go ahead and have them sent out to the jury.
I don't dispute that, Judge. I know normally it's the court's practice to have 2 separate rooms for alternates to not be with the jury. I know we didn't put it on the record. I just want to make sure that that's very clear.
It is, and I've got their names. Let me get the bailiff.
What, the alternates stay there in another room the whole time?
Mr. Miller.
I just wanted to make sure.
You don't send them home?
Okay. The 4 alternate jurors.
We're just asking that they stick around. I asked Mr. Weinstein.
I'm
I
gonna-
assumed that.
I'm gonna let him, always let him stay.
I know, Judge. Thank you. I appreciate that.
All right, then we'll be in recess until we have a verdict.
Thank you, sir.
Ms. Baker,
Yes, sir.
if you and Mr. Weinstein, this doesn't,
I wonder if she was the one that was laughing, not like audibly laughing, but like, yeah, I think that was the one. She was like smirking. I don't know if it was yesterday or the day before, but she was like visibly smirking, like it was just ridiculous what they were talking about, which it was, but. Really? I didn't know that. I thought they always sent the alternates home, but told them still don't watch anything in case you're called back. Okay, guys, what I'm going to do now is I'm going to end this stream and I'm going to keep an eye on this and I will do a news stream if there's a verdict. But right now, I'm going to start a new stream and we are going to try to get finished with the Phil Spector trial today. And if we can get finished with that today, then tomorrow we're going to have a members only live stream. And I am going to go over Michael Proctor's IA report with you guys. So if you're not a member, please join so that you can join the members only live stream with me tomorrow. If we don't get through Phil Spector today, we'll finish up tomorrow and then do the members only live stream on Saturday. But I'm hoping that we can get through Phil Spector today. So this will redirect you to the Phil Spector stream. And I will see you guys over there. And I will keep an eye. Judy and I will keep an eye on this so you won't miss the verdict. We will stream the verdict of this trial. So I will see you guys over there in just a few minutes. Bye.